in 1993, and it has continued for over 3 decades. It has seen now, if we add these elections, 9 democratically elected presidents and 9 parliaments. It has also witnessed a transfer of smooth and peaceful transfer of power from one political party to another political party. This constitution has survived the passing of a sitting president, and then power transited smoothly again. Again, this constitution has witnessed, for the first time, where we had a speaker who is not a member of the government. And the republic survived it. And then, so in short, the point I am trying to make is that we cannot run away from the fact that the 1992 Constitution has been our most resilient Constitution. Yeah. So there is certainly something about it. Yes. And one of the things about that Constitution is the fact that it was the Constitution that was passed at a referendum, adult suffrage, and it had over 92% voting yes. So there is something in a document like that that has survived and continues to survive different scenarios, different circumstances, and it is still carrying us through. That is not to say that it is perfect. As we just heard the president-elect say, we've practiced this for some time, so we also see aspects that are in need of improvement. So there is a basis for proposed amendments, and these bases include the fact that we need improvements in certain aspects of the Constitution, and we also want to deepen democracy and the democratic principles that we practice. So, in short, we had the minister responsible for parliamentary affairs who put together, who wrote to certain institutions to nominate persons onto a committee for purposes of taking another look at the Constitution, and also the CRC work that was done. As we know, the major work since the 1992 Constitution with respect to review of the Constitution was the CRC's report, the work that through Professor J.E.A. Mills, the Constitution Review Commission is the first major work step taken towards a review of the Constitution. But we all know that it did not end up in an amendment. And that report was in 2011. So the process was revived again, because we have to agree, as you heard the president-elect as well, that time has passed. Things have changed. So we needed to revisit those recommendations and also see what the way forward in terms of amending the Constitution. So the minister responsible for parliamentary affairs put together institutions, and these institutions nominated their own persons. So they nominated their own representatives onto the Constitution. The effect was that we had a very diverse, inclusive, and independent committee. The interesting thing was that when the committee eventually assembled, we realized that we had someone from the consultative assembly, the consultative assembly that produced the 1992 Constitution, and certain people who had worked with the CRC as well, and then senior citizens as well, and then of course young people as well. So the mandate of the committee, or the terms of reference for the committee, was one to review the Constitution Review Commission's report of 2011. After this report, there were a lot of stakeholder submissions, over 60 of them. Over 65 stakeholders made proposals with respect to amendment of the Constitution. So we also reviewed those stakeholder submissions. Submissions were also made on various constitutional review platforms. And then, of course, part of the TOR included to make recommendations to the Minister of Parliamentary Affairs and its partners and collaborators, and then submit a report on suggestions of firm resolve for a review of the Constitution. Now, what strategy did the committee adopt? First was that the committee decided that we will not redo or undo what the CRC did, but rather we would build on what the CRC did and then include changes that may have occurred since the 12 years ago when the CRC report was authored. So to do this, the committee adopts the CRC recommendations where same is not overtaken by events. harmonizes the CRC report with the government white paper and as well as the over 65 submissions received, and then consider whether there are more efficient ways to achieve the same objective. And then, of course, once we consider all of this, we then made recommendations. Now, the approach that the committee adopted was a clause-by-clause consideration of the entire Constitution, vis-a-vis what I just talked about, the CRC report, the stakeholder submissions that I just talked about. So we go clause by clause, and in measuring the clause by clause, we had certain underpinning values. And these underpinning values were liberty, equality of opportunity, prosperity, inclusion, respect for diversity, freedom and justice, accountability, rule of law, protection and preservation of human rights, unity of our nation, stability of our nation, sovereignty of the people of Ghana, respect for our cultural heritage, friendship and peace with all peoples of the world, and then other democratic values. So in terms of the recommendations that we make, these are the underpinning values. We also took the approach that constitutions are broad frameworks rather than manuals. This is because there were a lot of stakeholder submissions that wanted certain details included in constitution, but that's not the nature of constitutions. So we had to bear in mind the nature of constitutions when we were making the recommendation. But the entire objective at the end of the day was to ensure that this report reflects who we are as a people, so it reflects a certain Ghanaian identity, where we are 12 years on since the CRC report, where we want to be in our democratic journey, and then the aim or the objective was to recommend a constitutional framework that puts us in a position to pursue the Ghanaian aspiration for democracy. The process, briefly on the process that we undertook, it was a comparative process, so there were a lot of meetings, physical, residential, virtual, a lot of analysis. We received briefs, analyzed other reports, held validation workshops with several entities, national, international, some included CSOs, traditional, ordinary citizens, retired Superior Court judges, current parliamentarians, retired parliamentarians, private citizens, business people. We participated in validation workshops with these groups of people so that at least the recommendations that we make, they could give us feedback and their perspectives on it. The committee also had certain guiding principles, and these principles were: one, does it belong in the Constitution or it belongs in an act, regulation, political party constitution or other document? Then two, people made suggestions. We look at the suggestion and we look at the current provision. Does the current provision achieve the effect? If the current provision achieves the effect, there is no reason to disturb the current provision. We leave it as it is. And then number three, for the suggestions that were made, we consider, is it consistent with the clear values of the Constitution? If it's not consistent with the clear values of the Constitution, there is no need to take it on board then, or add it, or it should be modified to reflect the values of the Constitution. Now, what was the scope of the committee? We limited ourselves to the 1992 Constitution in terms of the recommendations. So that means that we were not making recommendations for other pieces of legislation like Acts of Parliament or CIs or other administrative requirements. So this is in brief, this is the procedure or the process that we use to come out with the recommendations that we are now going to look at. So now let's look at a sample of the key recommendations. The first one is the procedure for amendment. We are aware that the CRC recommendation was to group them in the two, the entrenched and then the not entrenched, but all of them would be in one bill. What it means is that if you were going to have a total of 30 entrenched clauses that were going for a referendum, you vote yes or no for the 30. Now, the committee took the view that if you do this, you are more or less railroading, considering that the 1992 Constitution itself was voted for at a referendum. So if the people said that for these particular provisions, if you want to change them, come back to us, we must do likewise. So the recommendation was that after at the end of the day, we consider which proposed amendments fall within entrenched and non-entrenched provisions and then pursue them accordingly. So for the ones that fall within entrenched provisions and so require a referendum, the committee's recommendation is that the proposed amendment must be grouped under the applicable subject matter and relevant consequential amendments and pursued separately in separate individual bills. In short, if you want to look at a particular subject matter, look at that subject matter, allow people to vote separately whether they want it or not. Let's take an example is just the aborted referendum, which was for the election of MMDCs. We realized that whilst people wanted to elect their MMDCs, they didn't want to elect them on partisan lines. So you give people a choice if they understand it and they decide that this is what they want. So the proposal is that group them separately and then allow each proposed bill to be voted for. So the persons can vote separately for each bill. If they like this, they vote yes. If they don't like this one, they vote no. Rather than put all of them together where they may like 5 and then they don't like 5. If you put the 10 together and they're supposed to vote, then what are they supposed to vote for? Yes or no? Because they like 5, but they don't like the other 5. The committee's view is that this gives the people of Ghana the opportunity to reflect on the effect of each amendment and decide whether or not they want that specific amendment. The benefits would be a real opportunity for individual reflection and then decision on each bill. For the ones that fall within non-entrenched provisions, it's much easier, as we know. So this one, since it is Parliament that would be dealing with that, Parliament can decide how they want to proceed with it, whether they want to proceed just like the ones for referendum, or they want to proceed differently. A third recommendation was, of course, what the CRC recommended, which is do all of them in one bullet bill. But our recommendation is, at the end of the day, as we noted, we go for the popular consensus. Let the people decide which they think really works for them. So now, if you are going by the first one, which we talked about doing separate bills, you must have a priority list for consideration. So what the committee also did was to seek to look at what a priority list would be, because you would need to decide which of the provisions you want to pursue at what time. So the recommended priority list includes one that we look at the caps to cap the appointment of ministers of state, and then also, which of course would go with capping the constituencies in Ghana. Also look at the appointment of ministers from Parliament. Of course, that the president must pay tax, election of MMDCs, and then emoluments and conditions of service of selected government officials. That is the Article 71 holders. Mm-hmm. We also, the SIT is to look at appointments of independent constitutional bodies such as the EC, NCC, SHRAJ, and then the provisions on the declaration of assets, the National Development Planning Commission, functions of the Commission on Human Rights and Administrative Justice, and then fundamental human rights. So these were the priority lists that we looked at. Now, considering, of course, so we are going to do the selected recommendations. As I noted, we can't talk about everything within this. You have
a priority list on which you have John Mahama proposing that he would also want to scrap ex gratia. Yes. Interesting.
Exactly.
Let's go on.
Exactly. So we give the priority list. The president-elect can say that this is the one I want to prioritize and then take a look at. So let's look at the key recommendations that we make. Now, so in this, we are putting the two key reports side by side so that we see where the changes are. If you take the issue about appointment of ministers, which is dealt with in Article 78(2). Now, if you look at the CRC recommended that we should leave it open for the president to appoint, which means that the president can appoint as many as the president wants. Now, the CRC has taken a different view, in the sense that the CRCC says that, no, let's not leave it open to the president to appoint as many as the president wants. Let's cap it. So the proposal that the CRCC gave, as something noted earlier on, was that the president should not appoint more than 25. But when we went for the stakeholder engagement, which included the two main political parties and more, all other political parties, they all said that they will not agree to the 25. But they would be willing to reach a consensus of 55. So they proposed a consensus. They agreed in principle that let's cap the president's power to appoint the number of ministers. But they disagreed with us on the number. We are asking 25. We say 25 is fine. They are asking for a consensus of 55. But they agreed to the cap. Now, secondly, and
I remember Samoku Jeto.
Yes.
The Venerable Samoku Jeto insisting that they should also not come from Parliament.
Yes, we are coming to that one too.
All right, go ahead.
Yes. So now, if you look at the number of MPs, for example, the CRCC did not recommend a cap. Again, the CRC did not recommend a cap, but the CRCC recommends a cap. We are saying that let's not just cap the president's power of appointing ministers. Let's also cap the number of parliamentarians. Let's cap parliament. So we proposed a cap of 277. Now, let me give a reason. The reason is that we already have 276. Now, we cannot, if we want to cap parliament, the committee took the view that we cannot say reduce the number of parliamentarians. Because if you say reduce the number of parliamentarians, we can all guess what will happen. We are all in this country. No political party is going to agree for the constituencies in its stronghold to be reduced. On the other hand, each political party will have very good reasons why the constituencies in its opponent's stronghold must be the ones that must be reduced. So we took the view that it would bring unnecessary acrimony. So let's maintain what we have, but an odd number is ideal. So we can just add 1 to make it an odd number. So it is the reason behind the 277 that the CRC recommends. Now, another contentious issue as a country that we've been dealing with is whether or not members of parliament should also serve as ministers. We know that as under the current constitutional dispensation, the requirement is that majority of ministers should come from parliament. So necessarily, parliamentarians will serve as ministers. We have seen how it has worked. Has it worked well for us? Now, if you look at the CRC, what the CRC recommended was that let's leave the president a free hand to decide whether they want to appoint from parliament or they want to appoint from outside parliament. So what it means is that the president can decide to appoint all from parliament or none from parliament. The CRCC says that no, we agree that we should give the president a free hand to appoint from within or without parliament. However, if you are a member of parliament and you are appointed, then you must vacate your seat. So you make a decision whether you want to be an MP, whether you want to be a legislator, or you want to be part of the executive, but no mixing of the two. We were not unaware of the history that led to this provision, which was that in the Third Republic, the president's budget was not approved. The consideration was then that if you make some of the ministers from parliament, it would make things easier. Our point is we have practiced it. Now, even with the benefit of hindsight, what is wrong with a budget not being passed? Parliament is supposed to serve as a check on the executive. So what is so wrong about a budget failing to pass if there is good reason for it? And for that reason, we have to appoint ministers from parliament. In any case, we've worked with it. And a lot of parliamentarians agree, or there are some parliamentarians who agree that left alone, they are not interested in the work of parliament. The only reason they contest parliamentary seat is because it is a means to getting ministerial appointment.
Right.
In which case, the work of parliament is going to suffer. So we make the recommendation that make a clean break. You either want to be an MP or you want to serve in the executive. If you are an MP and the president decides to appoint you, it is up to you to decide whether you want to accept the appointment. If you accept it, resign.
I'll need us to fast track a bit, and you conclude on this, and then we go to the steps forward.
Okay.
Right.
So so of course, then the election of the MMDCs, we recommend that it should be by election, but on non-partisan basis. With respect to the emoluments of Article 71, we propose that just have a predetermined formula, and then after that, the Fair Wages and Salaries Commission can manage that formula rather than keep on setting up committees. So they manage like they do for everyone else. And then let me talk about this one too. We also take the view that with respect to appointment of independent constitutional bodies, that it should be by open competition. So open it up, advertise the position, have rules and regulations, pass a legislative instrument, let people apply. Then at least the EC can rest from all the suspicions from the various political device and all of that. We also recommend that when it comes to declaration of assets, don't just declare, it has to be verified and a certificate of verification issued. Now, of course, we have a recommendation on the quorum of parliament as well. So let me go straight to the next step, right?
Right.
So this is a sample of the recommendations that we have. And with respect to our next steps, we are committed to ensuring that the voices of the Ghanaian citizens are central to the constitutional review. We take the view that these are recommendations or suggestions to the people. It is important to have the people agree or disagree or modify whichever way suits them. So what both the president and the president-elect have talked about, we do need broad stakeholder engagements across the country to get the citizens involved, and then to reach a consensus on the way forward, what kind of democracy we want, what recommendations we want to go by, and then pursue accordingly. So in short, these are the next steps that we recommend, that it shouldn't just be taking hook, line, and sinker. It should be presented to the people for their view on it. Thank you very much.
Thank you. Thank you very much, Clara. And I'll come straight to Oseche Mensah-Bonsu, who has oversight over this, and his ministry propelled all of this. But I also have not forgotten that sometime in 2018, actually the Attorney General, Gloria Akufo, had set up a committee. The Attorney General, Gloria Akufo, has set up a committee that she called the Constitution Amendment Review Committee. Of blessed memory, Professor Henry Kwesi Prempeh, Henry Taki, Chief State Attorney, you had Heidi Boache, you had several other people who were to do a number of things, review the Constitution, among other things, the proposed amendments, how they were to be gone about. That was in 2018. Then you come in which year, and decide that this is how we have to go. Why is this that important, that it doesn't leave any government?
Thank you very much. Let me first express my deepest appreciation to Madam Clara T. Keseti for what profound work that the committee has done in trying to align and synchronize the various reports that they work with. A huge load that they put into one basket and endeavor to sift, and they produce a very wonderful document for us. As we said, we've lived with this constitution for the past few years. I've gotten to know the various deficits in the application of the constitution. So to some of us, the practitioners, we came to a conclusion that we needed to offer some twists and turns at various provisions. So I remember early 2018, I raised this matter, and with Gloria, who was the Attorney General, and she indicated to me that she agrees and that something ought to be done. It was really ensuing from what we had started doing at the ministry with the expanded leadership at the time. And we had come to some conclusion that we needed, as a way forward, to revisit what had been done by the committee that was set up by Professor Mills. So that's how the whole endeavor got off the ground by the then Attorney General. But independent of her own effort, as I said, we had already begun our own at the Ministry of Parliamentary Affairs. Unfortunately, along the line, her endeavor fizzled out, and then ours then grew. And then together with my colleagues and compatriots, the Honorable Fuseni Inusa, the Honorable Ben Abdullah, who at the time, the two of them were with the Constitutional, Legal and Parliamentary Affairs Committee. And that's why I so much leaned on them to join me to get this onto the track.
Gloria Kufu's committee was looking to do, if you like, piecemeal implementation.
Absolutely.
So they took one by one and proposed how to go about them.
That was the difference between what we proposed to do and what they set out to do. And so the combination of events is what has been related to by Madam here. And I think she's not even related to all the aspects. For instance, dealing with the executive. I mean, we all acknowledge that the powers and responsibilities vested in the president, too huge, too many. How do you cure that? Is it to submit some of the appointments that the president makes to Parliament for approval so that it becomes a shared responsibility? It's one matter that is outstanding, and we need to make progress, which is already related to the appointment of cabinet ministers to come from outside, the number, the presidential travels, whether once the president travels outside Ghana, he ceases to be a president such that the vice president should take over. And in the absence of the vice president, the speaker also takes over. These are matters that we need to deal with.
She was on this same platform. She was on this same platform. Sorry about this brief interruption. With Anthony Forsing Jr., former president of the Ghana Bar Association, who was also the youngest in the Consultative Assembly that made the 1992 Constitution. And when they suggested a capping of the ministers to 25, there was such popular support for it. Then you go for...
Contestation now has to do with 3 against 88.
3 polling station we agreed last week and this morning. And then we are coming to do the 3 polling station. Massa, the young man has lost. I make reference to the MPP. You understand? He should come back the next 4 years and then make his own work. He has lost. That's nothing. So we are here to do the 3 polling stations. Nothing else.
The subject about 88, because you're making the case that they weren't a part of the process.
Look, after the 88, 11, or all those things, it's non-starter. We agree on 3 polling stations since last weekend, this morning, in IPAC. You understand?
The IPAC meeting this morning.
This morning. From there, we move to the coalition center. You understand? You don't have the PCs. Ask them. Whether, look, since last week, they asked them. They should bring their PCs. They don't have PCs. You understand? And then the MPP were able to provide, the NDC are able to provide their PCs. You don't have the PCs. How do you justify your case? Massa, Makwe lost the thing. He lost.
So for you, that's.
Come again.
So you expect him to agree?
Massa, that is it. It's simple as that.
Thank you. All right, thank you. And so that's the PNC's candidate who says that he's here representing his agent, and it looks like some headway may have been made with respect to what is expected to happen now going forward. And so we will seek to get an understanding again, really, from here on in as to what should happen. Banabio is the director of elections, is seeking to provide a bit more clarity at this point in time.
Broader national consultation.
Absolutely.
So the people's views
would matter.
What will matter?
Would matter.
All right.
In fact, we were intending to do after this one, the next step for us was to have some cross-sectional representation to interrogate the issues contained in the report. After which, perhaps we'll lead ourselves to maybe a consultative assembly or whatever. Because, as we said, this constitution was validated by the general populace.
That's right.
So ultimately, it will have to go back to them. And that is what maybe, sometimes we disagreed on the processes and procedures. Some of us do think that we can box everything together at the consultative assembly level to have a new document, and then we shall have just one referendum on that. If the people approve of it, it then supplants what constitution, and it will cut down the cost.
Right.
But that's something left.
We're talking about the importance of this,
Yes.
and why
Yes.
no government appears to